Good evening and good morning, everyone, depending where you are. My name is Ayala Berman, and I'm Senior Research Fellow at the Center for International Law at the National University of Singapore. It is my great pleasure to welcome all of you to our panel, COVID-19, a New Surveillance Era. We have many attendees from all over the world, and I think if there is one silver lining from all of this COVID, is that at least we get to make these kind of events internationally accessible. The panel is co-sponsored by the NUS Center for International Law and the American Society of International Law, International Organizations Interest Group. It is also the 8th installment of the CIL COVID-19 and International Law e-webinar series. Recordings of past sessions are available on the CIL website. Before we begin, I'd like to kind of set the scene really in short. I made a couple of short notes. So in the past decade, the world has been undergoing a digital transformation. Therefore, it should not come as a surprise that to try to slow the spread of COVID-19, governments around the world have been increasingly using digital surveillance tools. Tracking apps, QR code scanning, and other technologies are being used in a way like never before to track our movements. On the one hand, such digital tools arguably allow for much more effective control of the pandemic and could therefore be seen as entirely justified. On the other hand, they potentially open the door for abuse and could pose risks for privacy, human rights, and democratic freedoms. While concerns about digital technology and privacy are not new, there is concern that COVID-19 related tools will tip the balance in the fight for privacy in the digital age. Therefore, there is a good case to be made that if this technology is to serve society well, it needs to be guided by laws and regulations. But just as with other areas of digital transformation, where technological innovations are moving fast ahead and regulation is lagging far behind, here too, there appears to be remarkably little regulation at the international, national, or industry level that sets clear guidelines and accountability in the use of such technologies. Therefore, today, we want to look at these issues and start getting a better understanding on questions such as what technologies are being used, what are the benefits and risks, how, if at all, is this being regulated in different countries and under international instruments, and going forward, how should these technologies be regulated? And also, given the different privacy philosophies in different parts of the world, would any kind of international agreement or cooperation on these kind of issues be feasible? So against this background, I'm absolutely thrilled that we have a fantastic panel with us today, bringing diverse perspectives from practice, academia, and the United Nations. I'd like to introduce you to them. Our moderator, Professor Simon Chesterman, Dean of the NUS Law School. Hi, Simon. Vivek Krishnamurthy, the Samuelson-Glushko Professor of Law at the University of Ottawa. Peggy Hicks, the Director of the Thematic Engagement, Special Procedures and Right to Development Division at the Office of the United Nations High Commissioner for Human Rights. And last but not least, Benjamin Wong, Sheridan Fellow at the NUS Faculty of Law. So thanks again, all of you, for joining, and I look very much forward to an interesting discussion. I'd like to hereby give the floor to you, Simon Chesterman.
Thanks so much, Ayelet, and let me join you in saying good morning to those of you in the Americas, good afternoon if you're in Europe or Africa, and good evening to those of you in Asia or Australasia. Welcome to one of a great many series of discussions about COVID, the implications. Today we're obviously focusing on the legal dimension, in particular surveillance, but this has been a remarkable period in all sorts of ways. Because COVID-19 has changed many things about the world that we long took for granted. Many of us, particularly, I would suspect many people taking part in conversations like this who are used to a world of globalization, of global travel, the smooth movement of people. And of course, all of that has been brought to a grinding halt. Those of us who are interested in international law, international institutions, I can sum up some of the challenges that COVID-19 has revealed by the fact that one of the biggest changes is that the most powerful country on the planet is now in the process of withdrawing from the most relevant international organization, the World Health Organization. The human and economic cost of COVID-19 has, of course, been devastating. But if there has been one winner, it's technology. Technology companies in particular, those that facilitate video conferencing like this. Many of us had taken part in one, maybe two. Now it's a daily occurrence for many of us. And that's a great thing because it facilitates communication. But as Ayelet was highlighting, it also offers two sides to the pandemic: a benefit in terms of the ability to track, to locate, to confine the disease, but the possibility that the use of technology will go far beyond that. And maybe just to personalize this for a moment, earlier today I went to the Bukit Timah campus. I'm not in fact there now, that's a picture of it behind me, but I went to this campus. Previously I had to scan in, now that's all done automatically by tracking my Wi-Fi signal. There's a convenient little app on my phone that gives me an alert if I'm in the wrong zone or on campus on the wrong day, or if I haven't made my mandatory health declaration. A different app on my phone tracks my interactions with people for the government, which in the event that I, they, or anyone, any of us has interactions with tests positive for COVID-19 will enable all of us to be contacted. Now, if you'd asked me a year ago, would I be willing to let the university and the government have all of this information about me, I would have been outraged. I would have said, no, I only want Google, Facebook, Apple, and so on to have that information if I'd thought about it. But today I accept it. A year from now, however, 2 years from now, will we look back on this period as Ayelet said, the moment when we sort of allowed rights to privacy to be tipped in a direction that we're no longer happy with? Will the tools being used to control the pandemic ultimately be used to control us? Today, it's only my job to ask the questions, and we have three fantastic speakers to try and give us some answers. What we're going to do is I'm going to throw a couple of questions to them, do a few rounds, but then we're all really looking forward to the questions that you have to ask us. Now, given that we've got well over 100 people already in the room and more joining us at the moment, you can use the Q&A function down the bottom to type in your question, or if you see someone else has asked a question you really want answered, then please upvote it, and we'll try to get to as many of those questions as we can. But let me start off, and I'll go in the order that they were introduced: Vivek, then Peggy, then Benjamin. So Vivek, starting with you, you've got a really interesting background. The bio's online. We're not going through your whole history, but you've got a really interesting background in looking at the regulatory and human rights questions surrounding new technologies. You've done work with government. Can you start us off by outlining some of the kinds of technologies that are being used or may be used by governments and others, whether they actually work, and how they might be regulated? So Vivek, over to you for a little while.
Sure. Thank you, Simon, for the question. I'd just like to thank CIL at NUS and the American Society of International Law for organizing this wonderful panel on a very topical issue. So the way I see it, when we're talking, so there are a lot of technological implications of COVID-19 that are beyond the scope of what we're discussing, including questions of misinformation, disinformation, privacy on Zoom. We think we're really talking today about technologies being used to combat COVID. And I think there are three categories of technologies we should consider. Contact tracing is what has received probably the most attention, but there are also issues around what are known as immunity passports and techniques used to detect cases in the wild. So let's take those in turn, right? So contact tracing, of course, this is probably no surprise to anyone listening, is the technique that's being used to, when there's a confirmed case of COVID, to trace all the interactions that someone has had in order to get those people to quarantine and isolate and prevent the spread of the disease. Now, manual contact tracing has been with us for a long time. The Spanish flu epidemic of 1918, there was contact tracing used then. I think what's different now, of course, is the use of technology to augment contact tracing, right? And there's two basic technological approaches. One relies on the location information that your cell phone generates by virtue of connecting to a cell phone network. So the way cell phones work, and this is due to the fact that you can roam while talking on a cell phone, is that the network operator the Vodafone or the AT&T, has to know where you are in the world. So that information resides with the cell phone network operator, and that in turn can be used for contact tracing, right? So if we know where you are, we know who else has been proximate to you, we can use that to trace contacts when someone tests positive for COVID. Now, I think that was sort of an approach that was used in a couple of countries, notably Israel. One of the problems with it, just from an efficacy perspective, is that the spatial resolution on cell phone signals is pretty low. We're talking about 30 meters. So it generates a very large number of false positives. So the question is so in thinking about the use of technology in contact tracing, part of the question is, what's the delta? How much additional bang for our buck do we get by using these technological solutions versus manual contact tracing, right? And the promise is that human memory is fallible. I don't know who I've interacted with perfectly, and I may have interacted with people who I don't know. So that's the premise that animates technological contact tracing. But one of the big problems, again, with cell site-based contact tracing is this spatial resolution. So the dominant approach is to use Bluetooth. Now, every device that we have, my phone, I have an Apple Watch here, they all have Bluetooth, which we use to connect our headphones and to pair devices, share data. The way Bluetooth works is that whenever it's powered on, when you turn on Bluetooth on your phone, it's sending a little signal out in the world saying, hey, I'm here. So it can connect with the other devices that you've paired. Now, the idea here is to use those signals and the signal strength in order to kind of generate an approximation of how close you've been to a person and for how long. Now, the first Bluetooth-based approaches, like the contact tracing apps in Singapore and India and other places, were developed in a way that uses the unique identifier of your device to figure out who you are for contact tracing. So every device that your Wi-Fi, your Bluetooth, you name it, has a unique identifier tied to it. So that creates privacy concerns because it uniquely identifies who you are. And it creates greater possibilities for tracking and surveillance. To their credit, Apple and Google, two very strong rivals commercially, when they paired up to create a better Bluetooth-based solution for contact tracing, they really significantly improved the privacy protections by using anonymous identifiers that rotate over time. So that is considerably more protective of privacy than just using the signals that the device emits in general. I can talk more about the specifics of the technology if we'd like to. But to sort of step back and think about the implications, I see a few different ones, right? One is a question of inclusion, right? So if we think contact tracing is a good thing and digitally assisted contact tracing is useful in combating COVID-19, we would want to have as many people as possible participating in these programs. So partly that means, do people have devices? And since most of the contact tracing efforts in most countries have been based on consent, is the architecture behind them one that people feel comfortable consenting with? And I think consent, of course, is a basic requirement, but legally in terms of human rights protection, people should be able to opt into these systems, right? Because they are, even when well architected, invasive of privacy to some extent. But then there's the questions of efficacy, right? So I talked a bit about the false positive problem with regard to the cell site-based implementation in Israel. There's also false negative issues, right? So anyone who's tried to pair two Bluetooth devices knows how flaky the connections can be. So these signals are maybe first or second approximations of how much contact you've had with someone, right? So there's going to be an improvement for sure over manual contact tracing in detecting certain kinds of contacts, but there's going to be a percentage of false negatives, which means that we can't just rely on the technology. So pulling back again, part of the question when you're implementing any kind of technology to solve a social problem, this is something that I've addressed in practice and think about from a scholarly perspective, is what are the human institutions into which the technological solution is being embedded, right? So we can think about that from a public health perspective, like what is the architecture and mechanism of contact tracing in a particular country, but we can also think about it in terms of the data governance and privacy issues, right? So I have this technology, it's set up in a particular kind of way, it's generating a stream of data. The question is, what does the law say about who gets access to it, under what terms, et cetera? So I think some basic principles, again, if we're going to protect privacy, right, are to have relatively strong protections about when it can be used, right? Presumably, if you want uptake for public health purposes, you want it to be limited for public health purposes and not being used for other kinds of issues. You would want to think about retention and deletion policies such that, you know, the data is only good for 15 days because beyond that, that's the incubation period of COVID. So why would we retain the data beyond that? It's a good question. And I think it's one that Apple and Google have partly answered by having built into their systems deletion. We need transparency and oversight of the technology and of the human institutions too, right? So from a technological perspective, we want the code that underlies these apps to be audited, to be open, to be subject to inspection and verification. And similarly, the institutions that handle the data need to have strong transparency, oversight, and accountability, right? And in my view, they ought to be, the data ought to reside in institutions that are designed to promote public health rather than national security, right? Then there are also some very difficult cybersecurity issues, again, just around protecting the data against inadvertent exposure, because we are creating a log of people's movements or of their interactions. That's very sensitive. It reveals a lot of characteristics that can be misused by the wrong kinds of actors, right? So we have to think about very strong protections. So I spent a lot of time on contact tracing. I just want to very quickly talk about immunity passports and case detection. So immunity passports are basically a 21st century take on the idea of vaccination records, right? And the idea here is that if the science shows that people who have had COVID have reliable antibodies, or if vaccines, and we hope they are successfully developed, the idea here would be to allow people to have greater mobility in society based on demonstrating proof of immunity, right? And that system could be administered in any number of different ways. We could have paper passports if we wanted to, but a lot of people are talking about using technology in different ways. I know that in the introduction, Ayelet mentioned the QR codes that are being used in China, in part, not as a formal immunity passport system, but rather as a system of permissions to access different areas. So there are a lot of different proposals on how to implement immunity passports. One is the digital proposals run the gamut from the credential is on your phone to something that's more automated, where again, as Simon mentioned about how he accesses NUS, using the Wi-Fi signals from his device, you could imagine an immunity passport scheme based on proximity signals, right? And that's going to raise all kinds of issues, again, around locational privacy and access, right? As well as scalability. Not to mention that these credentials are going to be in hot demand, so securing them is going to be quite difficult from a cybersecurity perspective. Lastly, I just wanted to briefly touch on the use of various technologies to try to detect COVID cases in the wild. So I think there was some spectacular news coverage back in April about an American drone company that was proposing to put infrared cameras on drones and fly them over public places to find people with fevers. And everyone got quite upset about this at first because it seemed very privacy invasive. And it is, right? It reveals a lot. It's a kind of a search of your body that reveals quite intimate characteristic, your temperature. But for context, I think it's important to, in talking about all these things, I think it's important to realize that we do live in a society of rather pervasive digital surveillance. So we have CCTV cameras deployed in countries around the world with relatively weak regulation, even the best regulated places. As Simon mentioned, We have a lot of concern about government misuse of locational data, but we entrust vast amounts of this kind of data to private companies who use it for various purposes. So I think so there are certainly concerns, I have concerns about the pervasiveness and persistence of the COVID-related surveillance regime. But I think we shouldn't lose sight of the fact that it fits into a broader architecture of digital surveillance by both public and private sector entities around the world, around which we need to have a more robust conversation.
That's fantastic. A lot of information, very succinctly presented. Thank you. And I'm glad you came back at the end to the fact that the information, a huge amount of that information is already out there, and it's not necessarily just a question of vacuuming up the information. It's the question of using the information that our smart devices are already collecting on us on a daily basis. And there's this interesting question that we might come back to about contact tracing, where, I mean, we might be concerned about technology being used for contact tracing, but some people might be more worried about a police officer interviewing you, asking you to name everyone that you've met, and what happens if you don't do it appropriately, or whatever that dynamic leads to. And as you said, all the surveillance that's already out there. So these debates are not always carried out in a rational context. Sometimes it's very reactive. Mm-hmm. So that brings me to Peggy. I mean, you've got, you worked for a decade at Human Rights Watch. You've now been 5 years or so at the Office of the High Commissioner for Human Rights. Can you walk us through the human rights take on this? Because surely, as some governments are saying, the right to health, the right to life are relevant considerations. How does a human rights framework help us think about the trade-offs that are being made? And how can the UN help governments make good and sustainable choices in what some governments at least are treating as a legal emergency?
Great, thanks, Simon, and thanks so much for allowing me to be part of this panel. It's interesting that Vivek closed on the issue of the heat-seeking drones, because the High Commissioner has talked about COVID-19 as itself being something of a heat-seeking missile that can lay bare the weaknesses in our society. When you look at the way that it's exposed the impact of not having access to water, or not having adequate housing, or the racial disparities that we've seen in the impact from COVID-19. So, we do think that this intersection of COVID-19 and new technologies is a really important area. And Eilert started off by saying that the reality is we're already so far behind, and Vivek highlighted as well the fact that we just don't have the systems in place really to effectively regulate the privacy issues that are arising with the technology that's already in place, much less the novel things that are now being rolled out to address COVID-19. So my main purpose is to try to convince all of you, nearly 200 of you on this call, that human rights law is actually an incredibly useful tool in helping us work through these issues. And the reality is that when we look at these questions, there are huge tensions between rights, and those tensions have always been there in terms of how you effectively protect the freedom of speech versus the realities of the types of hate speech and incitement to violence that we see online, for example. The good thing is that the human rights framework's been around for 70 years now and has been developed to really put in place some of the standards that we need to help us address those questions and resolve it. Many people talk about the use of states of emergency in the context of the COVID-19 pandemic. But in actuality, most states haven't declared a state of emergency. They've simply relied on the exceptional measures that are allowed within existing human rights law that does allow restrictions on things like freedom of speech based on concerns for public health. It's already there within the covenants. But the great thing is, what it does is it allows us to not look at one dimension. It forces us to take a holistic approach at whatever intervention we're looking at and look at the full range of human rights impacts, rather than simply saying it's all about controlling the virus and that's the only thing that matters and we're going to do that. And we've seen that can have enormous consequences in terms of other activities that also have an impact on health, such as unemployment and lack of access to food and water. So what it does is it helps us to work through those issues. and basically sets in place some standards that would address some of the questions that Vivek has so artfully raised in his presentation. What it says is that when we're looking at how we engage with these new technologies, we need to look at things such as the legality. Is the technology being used in a lawful and transparent manner? Is it necessity? Is it being used for a legitimate purpose, and will it be effective in that? The efficacy issue that Vivek talked about. Proportionality, and this is the biggest issue I think that comes up, is the response designed in a way that is consistent with the threat? Or could it be done in a less intrusive way and still have the same impact or nearly the same impact? And finally, of course, non-discriminatory. Can we do it in a way that ensures that we're not making things worse for some people? So those are the key things we need to bring into the conversation about the types of surveillance and restrictions on privacy that Vivek has discussed. The problem is, of course, it's not really easy to apply them in the midst of a pandemic. What we've seen is, of course, our information and understanding of the virus doesn't necessarily allow us to as effectively judge whether a response is effective, whether it is proportional, whether it is necessary in the ways that we need to. That, though, isn't a fundamental blockage to applying these standards. What you do, of course, is you take the best evidence that you have in front of you, the facts and discernible scientific evidence that exists, and you put in place solutions that meet those tests for now, but you also critically have to continually be willing to reevaluate and monitor based on what we've learned. And I think I'll talk a bit about the contact tracing issue because it is sort of the central one here, but certainly the way that issue has evolved has really shown that, you know, the limitations of contact tracing may mean that some of the privacy concerns and surveillance concerns may in some cases really outweigh the necessity of the tool, because it's just simply not being used in a way that really guarantees any true advantage from a public health perspective. So when we look at those key questions of necessity and proportionality, I wanted to apply them briefly to the contact tracing technology, just to give a sense of how we look at it from a human rights perspective. When we talk about necessity, one of the things that Vivek mentioned is these issues of time limitation. The technology and the data retention within it need to be used with specific temporal scope that allows for them to be sunsetted when they're no longer necessary. So it's not just the data, but it's also the technology itself that needs to have a set purpose and time frame. As mentioned, they have to be justified by legitimate public health objectives. It has to be suitable to achieve that goal. And then very importantly, the way that it is used has to be consistent with the goal that's being set. So this goes to the fact that under many cases, many state laws, it is possible for governments to share information within governments. But in this instance, what we would argue is that you really should keep the information to those entities that need it for the public health purpose for which it's been created. So that means that the information should not, and it should be prohibited for the information, for example, that's being collected to be shared with law enforcement or immigration authorities, or even other agencies that might have a different interest from an employment perspective or something like that. On the proportionality side, we want to look at, as I said, whether it's the least intrusive possibility to achieve the goal. So that, as Vivek has talked through, you know, what type of tracking makes the most sense and what type of data collection makes the most sense. There's been a real move towards decentralized data collection, for example, because the advantages of doing it differently simply don't outweigh the privacy risks that are associated there. In the end, though, you know, what ultimately these tests require is that it actually has to work. It has to actually help achieve your public health goal. And that's the type of thing that we really need to look at. So, you know, one key test needs to be, you can't just roll out a contact tracing app. You have to do testing and treatment along with it. And those have to be equally resourced and effective. It's not enough to simply have the contact tracing app on its own. And you also ultimately have to build that confidence with populations. If it's not downloaded by enough people, it will never be effective. And in fact, in Norway, for example, they really looked at this and decided it just wasn't making it a proportionate intervention because of a low download rate. And then finally, we look at, as I said, the legality side of it, transparency and explainability, Vivek has already hit on, and voluntariness as part of that. I wanted to briefly mention too how non-discrimination comes into play from a human rights perspective with regard to this technology. There's a real risk that using these technologies will exacerbate existing inequalities. Half the world's population don't have access to the internet. Of course, in a society in which mobile phone use is ubiquitous, it's one thing, but in many places this will be a dividing line, and it could very much mean that people that are already marginalized and on the outs in society in a way, such as migrants and indigenous peoples and other communities, are not addressed as substantially within the public health response as those who have access to technology. Also, of course, please bear in mind that we have seen these technologies being developed and incorporating many times technological flaws, inaccurate data that reinforces racial bias and discrimination in a variety of ways. And we have to be very careful about that. So finally, just concluding, I was going to say there are sort of 5 essential ingredients from a human rights perspective of the approach that we're going to take. The first is, whatever you're going to do, and obviously it's a pandemic, we need to move quickly, but you don't just roll something out and see if it works. You need to test it, you need to evaluate it, and then you need to be willing to continually evaluate and monitor its use to make sure that these tests of necessity and proportionality are being met. The second is it needs to be secure. Vivek has already highlighted that issue. We need to be very aware of the risks of this information not being used for its intended purpose. The third is that there needs to be proper oversight and ultimately accountability associated with the technologies. The fourth, and something that I hope we can come back to, is about the role of the private sector in this. Apple and Google, as Vivek noted, have really come forward with a technology that is useful. But there is a real tension here about what is the government responsibility to protect rights and what role do companies have to play in their own human rights due diligence, and what will we ultimately be able to hold them responsible for in terms of how these technologies are used as well. And finally, I would emphasize that no matter what we do, we need to involve civil society, we need the public to be engaged and informed for any of these efforts to work effectively. Thanks.
Thanks so much, Peggy. Again, a huge amount of information. I think we should absolutely come back to the private sector question, not least because I've long found it fascinating, as many people who look at data protection issues have, that people are so relaxed about giving information to technology companies that they're resistant to giving to government. And both the legal and ethical questions surrounding that we might well come back to. But perhaps segueing that data protection angle to Benjamin, my colleague at NUS. Benjamin, so we're both based in Singapore, and I don't think either of us would say Singapore is necessarily the world leader in human rights. Singapore has not signed the International Covenant on Civil and Political Rights, for example, although it's a reasonably safe place to live. We have a reasonably good government and so on, and it would argue that the important rights are nonetheless protected. Can you give us a sense of how these debates are playing out in Singapore, and talk about the sort of surveillance role that you see coming out of COVID-19 as we look back on this at some point, hopefully meeting in person at some point in the future?
Yeah, thanks for the question. I think Singapore is an interesting case study for the implementation of COVID-19 surveillance technologies. So let me begin with a bit of context for members of the audience who are not in Singapore. As of today, the Singapore government has deployed 3 main COVID-19 surveillance technologies. So the first one is probably the most well-known. It's called the Trace Together app. So this is the contact tracing app. And like most other contact tracing apps, It uses phones to exchange Bluetooth signals with other nearby phones, and these Bluetooth signals are later used for contact tracing purposes. The efficacy of this is currently debatable. The government has also started to produce trace together tokens, which are physical devices that function in the same way as the app. As of today, it is not mandatory for individuals to use trace together. The second surveillance technology is called the safe entry system. So safe entry is essentially a system where people are required to check in and check out whenever they enter or leave a location. For example, Bukit Timah campus. Right, so this allows the health authorities to identify the locations where an infected person has been, which is again helpful for contact tracing and also for potentially identifying COVID-19 clusters. The third surveillance technology is called the Homer app. So this is an app used specifically by people who are under quarantine for them to report their location, to prove that they have not, essentially to prove that they have not broken quarantine. As I understand it, if they fail to report their location, there is no penalty except they might receive an unwelcome visit from an enforcement officer who have to check manually that they are at home. So coming back to the question, I think the debate in Singapore about these technologies has been fairly mild. There certainly hasn't been a lot of public controversy or public pushback against these surveillance technologies. And in fact, I think the major pushback has been about inconvenience rather than the privacy implications. I would suggest that there are a few possible reasons that contribute to this, I would say, general acceptance of these technologies. The first reason is, I think, social-cultural. The sense is that there is not really a strong privacy culture in Singapore where people are instinctively suspicious or skeptical about government surveillance. By and large, I think there is trust that personal data is not going to be abused by the government later on. The second reason is legal. So Singapore has a legal data protection regime, which is under the Personal Data Protection Act, or PDPA. But in Singapore, the PDPA only covers the private sector, and it does not cover the public sector. So as far as government surveillance is concerned, there is no legal data protection regime. So of course, there are internal data protection rules that government officials have to follow. But these internal rules are not publicly available. And so the problem that arises from this is that this absence of legal rules that bind the government means that there is no legal basis that can ground the debate in Singapore about assessing the government's COVID-19 surveillance measures. And the third reason is, I think the government has been quite proactive in taking the effort to assure people that the surveillance technologies are as privacy protective as they can be. So for example, all the three surveillance technologies that I mentioned, there's been an express assurance that the personal data collected will be used only for purposes like contact tracing and dealing with the COVID-19 pandemic, and will not be used for any other purpose. And the government has also generally minimized the amount of data collected to what is necessary for those purposes. So I think these proactive steps have helped to preempt some of the potential objections that Singaporeans might have towards the surveillance technologies. So this is a bit of a snapshot of the state of play in Singapore, which, as I said, is an interesting case study, especially when seen in contrast with jurisdictions like the EU and Australia, where there has been more robust legal regulation of COVID-19 surveillance. So for example, in Australia, the Australian Privacy Act contains a specific section dealing with the Australian COVID-19 contact tracing app. So it sets out binding legal rules on how the data can and cannot be used. And for the EU, as of today, the European Commission and the European Data Protection Board has also issued guidelines on how the GDPR applies to contact tracing apps. So I think this is I think Singapore, the case study of Singapore contrasts interestingly with these more legal jurisdictions.
Okay, thank you very much. So look, we've got about just under a little bit more than half an hour. I've got a range of questions. I'm going to go back for one more round of questions to each of our panelists, and then I do want to get to the Q&A. And I see we've already got half a dozen or so questions. Please go type your questions, or if someone's asked the ideal question, please upvote it. But I wanted to pick up on a couple of threads, and I'll go back again in order, if you like. So Vivek, I wanted to pick up one thing you said and one thing Peggy said. The thing that Peggy said was the role of technology companies in all of this, really amplifying some of the things you were talking about. But in particular, to focus on what you highlighted quite rightly, is the legal foundation of a lot of these activities, which is consent. Now, everyone who works on data or has any interaction with data protection law knows that consent is often completely artificial. We regularly accept terms and conditions that we do not read. I mean, I would be shocked if everyone on this call if anyone on this call has read every single word of every end user license agreement or the terms and conditions. I mean, I've published books on data protection. I don't read them. So in one sense, that consent is artificial. But secondly, in an emergency situation like this, and we'll come back to whether this is an emergency or not, but at least when there is a compelling public health justification, are there situations in which consent is undesirable anyway? I mean, should we be relying on this artificial notion of consent when actually we have to do something, we have to gather that information, and it's just a lot more convenient to do it through devices than it would be if we had to deploy hundreds of people to do every bit of contract tracing, which would have other human rights implications. And then I suppose linking it back to the technology company question, that it's also unrealistic to expect government not to get access to this information somehow in a public health crisis, or however one wants to frame it, when technology companies have that information about us anyway, or at least some of it. So I suppose the question is really, to what extent can and should we rely on consent as the legal artifice to justify these actions, or should we really be moving towards a kind of derogation of rights framework where people just accept that governments are going to intrude upon their rights to privacy with some of the caveats that Peggy said we should be keeping in mind at the same time?
I think that's a really interesting question, Simon, and I'm going to do the classic law school professor move of saying it depends. So on consent, yeah, I think there is an argument that can be made, like a strong argument based on human rights principles, that this is a situation where consent may be undesirable. Now, that depends a bit on the facts of the epidemic and the way the disease spreads, and also in the efficacy of the contact tracing system, and what privacy protections are baked into it or not, right? So you could imagine an architecture where by default, there is no consent to the collection of this data, but the data collection is done in a way that is highly privacy protective by design, such that it can't be misused, right? So you can think about a sliding scale, right, as to, and data protection law recognizes that there are situations where consent is unachievable, right? And for example, the GDPR or PIPEDA here in Canada provides guidance on when exceptions to consent can be used as a basis for data collection, right? So I think that's a hard question to which there's no easy answer, but I want to talk a bit more about the role of tech companies, if I can. I think what's really interesting about the role that Apple and Google play in particular, they have enormous power in shaping the design and feasibility of contact tracing. They are the gatekeepers, because contact tracing is premised upon Bluetooth or other signals emanating from mobile devices, and they control that industry, right? They are the two quasi-monopolistic providers of cell phone hardware and of software especially, right? So under the UN Guiding Principles on Business and Human Rights, articulated by Professor John Ruggie almost a decade ago now, it's widely recognized that companies have a responsibility to respect human rights. Now, that has a quasi-legal dimension, but it also has a technological dimension, right? So there's a business process dimension around, Peggy mentioned human rights due diligence as being very important. Companies conduct human rights impact assessments when there's a significant a possibility of significant human rights impact from their activities, right? But one of the things that we're seeing, and this goes to the guiding principles and their emphasis on avoiding the causation or contribution of human rights, adverse human rights impacts by companies, is really thinking hard about design, right? And we can think about design in a technological context, right? How does the technology work? But we could also think about the design of the human interface and of the way in which consent is collected, right? So, you know, in preparation for this call, Canada does not have a contact tracing app, a national one launched yet. It should be launching soon. But I went through and did my homework to see what's the architecture of consent, right? And at least on iOS from Apple, in order to activate contact tracing, you need to go into 3 levels of menus to say yes, right? So do you know what you're signing up for? No, but there's a certain level, maybe not because you can't read the terms and conditions. It's a contract of adhesion ultimately. But there is a certain level of volition required to download the app and then turn that feature on in your phone settings, right? That evinces consent to that nature collection. So that's the consent side of it, right? But I also think the gatekeeping function is quite interesting in another way, which is that Apple and Google only permit apps that meet certain and government contact tracing systems that meet certain minimum privacy protections to access their highly efficacious Bluetooth-based system, right? So if you are a country that whips together something very quickly without adequate privacy protections, you do not have appropriate data minimization in place, et cetera, Apple and Google won't let your app access their framework, their API as it's called, for contact tracing, right? So I think that's really quite interesting in a way to see these two mammoth technology companies playing a quite important role in holding governments to account over the way that they're going to implement contact tracing based in part on their monopoly position in the market, right? So there's a lot of public policy issues we can unpack in thinking about this, from privacy law to competition law to human rights law, all kind of bundled up by this specific architecture that we're using.
Great, thank you. So Peggy, I did want to come back to you on this question of emergencies and the framing of the COVID-19 by various governments. As you highlighted, there aren't that many states that have explicitly adopted a state of emergency. I think Spain went through a whole iterative period of declaring periodic states of emergency for 15 days here and there. But many states, and in particular many political leaders, have used military or national security type metaphors, a war on the virus. For many of us, that's a kind of troubling metaphor, partly because it suggests you can just deploy resources and kill the virus, which is not realistic. It conjures images of an us and a them, which unhelpfully can cause greater fragmentation. And certainly at the very early stages, we saw a lot of racism. We still see some racism in the context of the virus. But it also suggests that it's a battle that can be won with a victory parade and the end. And so I wanted to ask you if you could talk a bit about how this kind of security angle affects debates over rights, because we've got now almost two decades of the post 9/11 situation in the United States, which really transformed a lot of the debates over liberty versus security. And for the most part, when there's a fight between liberty and security, liberty tends to lose. So I just wanted to ask you whether you thought there were lessons for governments coming out of that experience of the kind of compromises of rights by governments that we would not have expected that of in the course of trying to deal with terrorist threats. Lessons for governments, but also lessons for advocates. as to what is most effective in persuading governments and other relevant actors to adopt the kind of human rights framework that you were so eloquently articulating earlier. So what actually works in terms of persuading people not just to throw resources, vacuum up as much data as possible, and human rights be damned? How do we persuade governments otherwise?
Great, thanks, Simon. It actually, I think, to some extent, links back into the discussion that Vivek just led on consent. I mean, this issue of which governments and how they're going to do it is absolutely fundamental. And, you know, I would have also just said very boldly in response to your question about consent and you know, should we just let governments go ahead? That standard that Apple and Google and others have set about, well, if you have the right framework in place, then maybe, you know, that can be an approach that works. But the reality is that doesn't exist. And what we've seen, and I really appreciate the way you linked back to the post 9/11 securitization atmosphere, is that there are actors who will take advantage of any types of crisis, be it a security crisis, be it a health crisis, to do what they wanted to do anyways. And that is often to suppress dissent, eliminate political opposition, go after unpopular groups such as migrants and others. And we've seen exactly those trends emerge in the context of this pandemic as well. And you know, what we need to do is really make it difficult for that pretextual use of a public health crisis, because it's as you said, you know, but what works to do that? I think some of the lessons we've learned from the pretextual use of a security crisis is that we can't just be about the principles. I mean, I'm a human rights lawyer. Of course, I want to talk about what human rights law requires. But what we've seen as well is that it just doesn't work to do it that way, right? And it's absolutely just as true in a health context as it was in a security context. If you crack down on, you know, communities that you think are the at-risk ones, you know, for terrorism, and don't have relationship with those communities and aren't trusted by those communities, you will be less effective in controlling terrorism. The same thing applies on the health side. We need people's buy-in for all of these measures to work. And that means that we need to have a human rights respecting, transparent, and accountable approach if we're going to be successful in combating the pandemic. So I think part of the argument has to be why the human rights approach actually helps, rather than is just, you know, one more hurdle you have to jump through to be able to put a response in place. But I do think that whenever we're trying to answer these questions in the general sense, we have to look at not just the context in which we're currently living, but how would those measures be employed and used in other places? Because one of the other lessons we saw on the security side is that if a Western state adopts a content moderation law that puts in place things that might actually work given the sophistication and role that the courts and governments play in that context, that doesn't help us in that ultimately what we've seen is massive replication of those laws and other approaches in other places. And the same thing will happen on the health side as it happened on the security side. Counterterrorism law that might work in one place, if it isn't very strict in terms of making sure that those human rights protections are in place, it will be replicated in an environment that does not have the checks and balances of a place with a well-developed judiciary and executive that doesn't exercise, you know, absolute control. And that's what we need to be aware of when we're coming up with solutions here. We have to recognize the diversity of willingness and ability of states to put in place these measures in a way that protects human rights.
Thank you so much. So Benjamin, if I can come back to you, and then I'm going to go to the questions, and they've now got 14 questions. Some are being upvoted, so please keep editing that if you're in the chat in the call. So Benjamin, the Google and Apple API, as you doubtless know, I'm not sure if you're familiar with the details, but Singapore's government declined to use their API and develop their own. There are protections in that, as you highlighted, but if you wanted to talk about Singapore's relationship with technology companies, that would be interesting. And then secondly, Singapore is unusual for a couple of more reasons, in addition to the ones that you highlighted. One, the relative small size, competence of the government and so on, and wealth, that obviously makes an impact. But also Singapore had previous experience. So I think the experience of SARS in 2002, 2003 really explains some of the ways in which Singapore partly did a decent job, Hong Kong, Taiwan, South Korea, to some extent China. And looking forward, to what extent do you think, assuming this happens again in other countries, the way in which the debate played out in Singapore 17, 18 years after SARS was different than it would have been if we were experiencing this for the first time, and so what that might mean for future debates about privacy, security in other countries looking forward?
Thanks for the question. I think I'll answer the second question first. I think that Singapore's situation is, I suspect, rather unique in the sense that, as you say, it is a very small state with a very efficient a government. So I suspect in Singapore, the level of public trust that people have with the government is, I suppose, uncharacteristically high. And I suppose in subsequent, if touch wood, a subsequent pandemic should occur, it may be the case that governments in Singapore and around the world may be rather quicker to jump to tried and tested technologies that have been attempted the previous round. So I suppose in that respect, there may be some concern that the unique features of different types of pandemics may not be carefully thought through when these technologies are applied. COVID-19 is an especially infectious virus that requires certain solutions that other pandemics perhaps may not. Sorry, what was the first question?
It was the extent to which Singapore is unusual. I think you've kind of answered that Singapore approached this differently because people did have a visceral memory of SARS, of death associated with that, although it was much less infectious, more fatal, but less infectious than COVID-19. So look, we're approaching 15 minutes to go. Let me go to the questions, and we've got a range. Too many good questions, but keep them coming. Peggy, I'm going to start with you because I think sometimes there's a danger we all assume a little bit too much. So this is a good, I often tell my students, there are no dumb questions, there are plenty of dumb silences. So I want to thank Renuka Puchayapan for asking just what are the treaties, what are the international conventions that regulate surveillance? Because we're all assuming that privacy is some kind of right. Technically in Singapore, there's no formal right to privacy in Singapore, but there are international obligations here. So Peggy, could you just walk us through, maybe taking a step back, what the baseline obligations and where they come from for governments derive, what treaties and customary international that derives from?
Great, thank you so much, and thanks for the question, Renuka. Look, this is actually far from being a question that doesn't need to be asked. It's something that we're actually really debating within the human rights community, because there's a real question whether the existing framework is fluid enough and adept enough at picking up the many dimensions of the human rights challenges that new technologies face. Now, that's an active debate, as I said, but I have to say that the starting point from our office and my own personal view is that there is a huge wealth of relevant legal standards within the existing human rights framework that can help us work through these questions. And before we start creating new law, we should start applying the law that we already have. And the law that we already have, in the context of privacy, we will look first, I think, generally at the International Covenant on Civil and Political Rights and the rights within it. You know, that's part of the overall International Bill of Human Rights and the Universal Declaration of Human Rights. But part of what we've seen as well is the interlinkages between the rights within that framework and those within, for example, the Covenant on Economic, Social, and Cultural Rights. And then the third piece I'd refer to that Vivek referenced earlier is the UN Guiding Principles on Business and Human Rights, which isn't a treaty. It is guidelines, but it is something that most of these companies have said in a variety of ways that they are willing and able to commit themselves to abide by. And there actually is a movement within the UN system and with member states to turn it into binding law, which of course was a big debate when the guiding principles were developed 10 years ago, as Vivek mentioned. So part of what we're working on is really specifically, how do we inform both governments and very particularly the companies themselves? What types of guidance can we help to give as to how they apply those complicated systems of law to these difficult issues that we've been discussing here? And within, for example, the treaties that I mentioned, there are expert bodies under those conventions that actually analyze and look at these issues. And for example, they just came out with guidance today under the ICCPR on the right to protest and peaceful assembly and how some of the difficult questions, and I think, I haven't looked at the final version, I saw an earlier version, but you know, it even gets to some of the issues of online engagement for protests. So the treaty bodies under those international human rights documents are really working to help us, and they bring a lot into the conversations on these issues as well. And of course, I'd be remiss by not mentioning that there are UN experts who have really unpacked these issues. Most notable in this field is, I think, David Kay, who is just finishing, we're in his last 3 days here of his term as the Special Rapporteur on Freedom of Expression, who's done a remarkable job sort of really outlining what the law says from a human rights perspective with regards to the issues of digital technologies.
Thanks, Peggy. You can really tell you used to be a teacher because you explained that very clearly. So Vivek, I want to ask you, I'll paraphrase Joel Fong's question, which in some ways follows on from Peggy's, which really is, can you give us some examples of, if not in the current situation, just ways in which governments and their contracted digital surveillance providers and others have actually been held liable? So if we do find violations, if we do find states, companies breaching these obligations, what can we do? What have people done in the past that might hold out hope of successfully restraining some of these very, very powerful actors?
Sure. So liability is quite difficult in this field. To the extent that I'm aware of governments that have been held liable for excesses with regard to surveillance, almost always it's in a domestic context. So in most democracies, quite controversially, citizens and residents on the territory enjoy enhanced protections, rights protections, but governments generally do not accord the same level of rights protection to non-citizens or people who are outside the territory, especially in the intelligence gathering context, right? So some cases that come to mind of when governments have been held to account, in fact, recently in Canada, there was a decision by our federal court that chastised our domestic security agencies' practices around informants and its processes for receiving authorization for surveillance. There are a few cases pending around the world that seek to go after surveillance technology providers on various legal theories. So there's one in the United States pending, actually brought by Facebook, interestingly, against Israeli technology company that is based on a violation of the US Computer Fraud and Abuse Act, which is a cyber crime statute in the US. So basically saying that their technology, as applied to WhatsApp, violates this particular US computer crimes law. There's a number of cases around the world that seek to hold other manufacturers of this technology accountable. Most of them don't go very far. What's more promising in terms of legal strategy, right, and I've been involved in some of this litigation, again, is in the domestic use of particular technologies by law enforcement or intelligence agencies, so seeking to adopt standards. So there's a series of cases in the United States, for example, on cell site location information and the conditions under which police can obtain it, right? Do they require a warrant to obtain it or not? And there's been a movement in the US to requiring judicial authorization before that kind of information is sought. And there's similar litigation going on in a number of courts around the world. I'd be remiss in not mentioning what's been dubbed the Schrems II decision in Europe just last week, which is, again, its ramifications are just beginning to be understood. In a nutshell for this audience, under the European Data Protection Framework, if a European company is going to export data to another country for processing, what's required is generally an adequacy determination where the European Union says that these laws are substantially equivalent to European law. The US has been operating under a special deal called Privacy Shield for the last several years. And essentially, the European court decision invalidated that data sharing arrangement on the basis of US law, particularly around surveillance, not providing adequate human rights protections in terms of judicial review, judicial remedies for those who've been aggrieved. So I'm not sure that's an entirely satisfactory answer, but it's not a very satisfactory state of affairs when it comes to legal accountability, again, for both government misuse of surveillance technologies and also when it comes to companies that provide technologies that run afoul of minimum standards.
That's all right, Vivek. I was once in a briefing where a politician was asked on the record various probing questions, and he said, by way of preface, questions I want to answer, I will answer. Other questions I will respond to. And sometimes all we can do is respond. Okay, Benjamin, I've got one Singapore-specific question and one question that really picks up on something you were talking about. So Raymond Chan asks, in the context of Singapore, how does the PDPA apply to contract tracing apps created in other countries? Since it's not based on a right to privacy, but a regulation of organizations. So to what extent would other contract tracing apps that are not exempted from legislation by the public sector exemption? And I'll just ask you the second question, which was Taylor Dalton's, which goes to this question of stickiness of measures taken in an emergency situation. So Singapore has not declared a state of emergency, but it has rolled out all these apps. And I think somewhere in the terms of service, I did read this one. It says, after the crisis is over, this app will cease to function. To what extent, not asking whether you believe that, but maybe generalizing a bit more, to what extent do you think that the kind of technologies that are being rolled out will become semi-permanent? Not necessarily for nefarious reasons, but because we don't know when the next pandemic will start. And if we've got all this stuff ready to go, then we'd be able to address it much more quickly.
Thanks. So I'll answer the first question about how the PDPA potentially applies to other contact tracing apps that are not the Trace Together app run by the government. Hard to answer in the abstract. So looking at the Apple and Google app, for example, I think it is difficult to see how the PDPA will apply because the Apple and Google app is a decentralized one. So right from the get-go, you have a problem with figuring out who you want to enforce the PDPA against because there's no central authority collecting all the personal data, all the data that is gathered by the app. The second problem is, of course, as I understand it, the way the Apple and Google app works is it does not necessarily collect personal data because personal data needs to be identifiable in order to be classified as personal data. And my understanding of the Apple and Google app is that the data is strictly anonymized, so it is impossible for you to, if you just have access to the Bluetooth signals that are sent, you will not be able to identify a data subject from that from those signals. So I think my conclusion would be that it is hard to see how the PDPA would apply to apps like these. For the second question from Taylor Dalton, my suspicion is that the surveillance measures that have been put in place will not continue to operate after the pandemic is concluded. What it means for the pandemic to conclude is, of course, another question. But I don't think that these measures will continue to operate. I suspect that they will be shelved and made ready for use in the future potential pandemics. But I think that there are certain costs as well associated with using these measures. So if there is no further use for these surveillance measures, I'm not sure that the government would necessarily these measures will necessarily be sticky.
Okay. All right. So look, we're almost out of time. One of the great things about the Zoom meeting is people tend to be on time, and we try to finish on time. But I do want to ask our panel for any concluding remarks, which I'm going to frame as a final question from me, with apologies to all those other great questions we didn't get to, which is, how should governments be making these decisions? Because one of the distinguishing features in many countries is whether politicians take the lead or public health officials take the lead. And so insofar as you feel comfortable, include that, as you can respond to that or answer that as you like, Vivek. But how should we be making these, who should be making these decisions? Maybe make it more direct. Politicians or public health officials? And I might just 1 or 2 minutes, pick up any final thoughts you want to make to the group, and then I'm going to be throwing to Ayelet to wrap us up. Vivek first, and then Peggy, then Benjamin.
Yeah, I think very quickly, I think that especially in democratic countries, these are decisions that do need to be made by elected officials, right? They're highly consequential public policy decisions. So democratic theory would say, like, those are the kinds of decisions that need to be made by elected officials based on whatever particular political system exists in a country, whether that's an executive branch decision or if it's a legislative decision. It's going to vary from country to country. That said, I think any decisions that are made have to accord with the domestic constitutional framework, the international human rights framework, and be based on evidence, right? And I think that's where countries that have been more successful at controlling COVID, the public health people have been advising political leaders on what the science says. And there's been a science-based and evidence-based approach to controlling the disease. And I think that has led to better decision-making and ultimately greater public confidence and better results. So I think respecting that kind of process is quite important.
So kids, don't drink bleach.
Right.
Peggy, over to you.
Yeah, no, I think Vivek has said what I would have said as well. It's the issue is making sure that, of course, the decisions rest with the policymakers, but that the policymakers are accountable for basing those decisions on the science and evidence. And for the only element I'd add in is that for that to happen, Steve Crown had asked a question about how do we make sure that governments are being transparent about what's happening. That's where, we really need to create the space for the types of discussion we're having now, and for people to be informed and for civil society to be engaged. And, those are challenging things in a digital environment as well. So just a last plug for us to really make sure that we're reaching out to people and allowing them to do that in a way that will hold governments accountable for doing it in the way that Vivek has described. And then at the same time, as we've talked about, making sure that the government role holding companies responsible for their engagement is being exercised in a responsible manner at the same time.
Thanks so much. Benjamin.
I guess I would also agree with Vivek that I think the democratically elected politicians should be responsible ultimately for implementing these technologies, because they are the ones who need to be held accountable in the end. And one does hope that they will take into account the views not just of health experts, but expertise from other areas as well, so that their policies can be made in a holistic fashion. I think a lot of the current debate has been focused on government surveillance, and rightly so. But I think it is also important to see that the pandemic has effects that go beyond just increased government surveillance. And here I'm talking about, of course, the private sector. So, for example, the pandemic has forced many of us to work from home, as I am now. And there is evidence that increasingly employers are relying on technologies like employee monitoring software to remotely manage their employees. And some of these software have fairly intrusive functions like keystroke logging, screen capturing, and so on. So this is one example of what I consider an indirect impact of the pandemic on surveillance, and also something I think we should pay attention to.
Thanks so much, Benjamin. I emphasize we do not have that at NUS. I've got no idea what work you're doing. I'm sure it's very good and very important. So look, I mean, part of this democratic accountability requires citizens to inform themselves. That's been the point of this debate. So I'll throw to, well, let me firstly just thank the panelists, thank all the participants. I'm sorry we couldn't answer all the questions, but Ayelet, back to you to close us out. Once you unmute yourself.
Yes, okay, sorry. Thank you everyone for such a rich discussion. I mean, there's really so much to digest, and this is really just the tip of the iceberg of this whole topic. I think what I'll just try to do in the minute or two that I have is to kind of give a bird's view of, I think, what comes out of this debate, because I think what really comes out, first of all, that from a regulatory perspective, we're once again dealing with a highly fragmented field. So we have many actors involved and a diverse set of rules. So in terms of the actors involved, you know, we first of all have different countries. You've mentioned Singapore, Australia, the European Union, the United States. Each of them have their different regulatory frameworks for these issues. At the international level, what comes out is actually that we have principled rules. So we have the international human rights law, and then we have the business and human rights guiding principles. I'll say something about that in a moment. And finally, we also have the private sector. So it's really not only about governments or international actors, international organizations, but really also the private sector, which is either acting out of its obligations under the business and human rights guiding principles, which I somewhat doubt. Of course, that might have a role, but also there are other, perhaps, you know, commercial drivers, market access drivers, and so forth for them. And perhaps also they feel some kind of responsibility to use their power for good, but they too have a role to play in this debate. And then the question is really how many of them already have industry regulation, so self-regulation going on. That's something that we haven't really had an opportunity to touch on, but that's also something that might be going on. So industry self-regulation on these kind of issues. And then finally, we have the issue of civil society and the public, which, as you've just mentioned before, should also actually play a role in developing guidelines and rules going forward. I think one of the main takeaways for me from all of this debate is something Peggy really highlighted, and that is that we have the international human rights framework, and that actually, you know, we have all the principles that we need there. So we really don't need to reinvent the wheel. Now we're talking about technology, but these are issues that have come up in the past. So the idea is really, how do we use these principles But then again, I still think the question remains, are these enough? Are they just principles, or do we need more specific guidelines? Again, because we have so many technology, as Vivek described so vividly, that, you know, that will really guide the use of technologies. So really, thank you for such a rich discussion. I personally learned a lot from all of this. And I think this brings our webinar to an end, unless some of you would like to add something more.
No, look, thank you, Ayelet, for coming up with this, for bringing us together, and thanks to all the participants for tuning in and asking their questions. And sorry we couldn't answer them all, but I'm sure this conversation will be going on for months, hopefully not years.
So I'd like to thank all of you again, and also, of course, our team at CIL, Jerry and Saway, for organizing all of this behind the scenes. Thank you very much. Wish everyone a good evening or a good day wherever you are.
Thank you.
Thank you very much.
Bye-bye.
Bye, everyone.
Thank
Bye-bye.
you.